The title of my presentation is How International Law Enables Great Power Domination and Great Power Competition, and What Can Be Done About It. Fundamentally, the paper and my talk is concerned with the dynamics which international relations has taken in the past decade or so, and asks what the structural enabling features of the existing international legal order are that makes this possible. And to get a handle on what I think is wrong in present discourse and what the real problem at least also is, I want us to begin with a pretty familiar kind of account, all related to the Russian invasion in Ukraine. Because I think all the kind of reactions that we see in this context are reactions that once we understand them, it kind of provides us with the basis for thinking about what is wrong with international law as it currently exists and how it might have to be reformed. So, when Russia illegally invaded the Ukraine in February 2022, the response of the largest part of the international community, more than 142 states effectively signed on to this, said, here is something that is a clear-cut violation of international law's prohibition of the use of force, the prohibition to undermine the territorial integrity and political independence of another state. This is in some sense a paradigm case of what the contemporary international legal order is supposed to prohibit effectively. And this is as clear-cut violation as we've seen in the past. So what are the reactions we can see in the world? Now, on the one hand, there's a widespread condemnation, not quite unanimity, but 142 out of 190-something states. That's, given political and diplomatic complexities, as close to a dominant consensus as you can get. But at the same time, what is striking is that what is absent in this debate is any kind of an idea that international law itself needs to be changed. So the reaction is kind of, this is like Britain before when Germany invaded Poland. Britain wanted to uphold the pre-existing order. It was basically a status quo-oriented power, and just wanted to make sure that Germany had to pay for that this new actor on the block, this new aggressive actor would be put in place, and its expansion and its threat to the international community limited. Now, the interesting thing, and if we use this as a historical parallel, is what happened when the United States got involved in this. They, on the one hand, they play the same role as they do today. They become the armory of democracy. So you deliver weapons, you provide support, you organize a coalition, you provide a support for against the aggressor. But from 1941 onward, when Roosevelt realized that the United States would eventually actually have to go to war, it was clear to him that, notwithstanding all the immediate actions that were necessary to support the Allies and the UK in particular against Germany, what you needed to focus on in the mid to long term was to ensure that this type of thing could not happen again, that you needed a massive transformation of the international legal order. And that is, of course, exactly what between 1941 and 1945 happened. So by the time World War II ended, the UN Charter had already been negotiated, creating a very different framework from what had existed previously. And also the Bretton Woods agreements had already been agreed to, and the institutions were about to get going. The IMF, the World Bank, negotiations for a world trade order were in place. So we have a situation where the United States interpreted what was going on in 1939, 1940, 1941 interpreted it was not just focused on Germany as the bad actor, even though, of course, Germany was the bad actor, but looked at this as a crisis which was a symptom of a wider deficiency of the existing international legal order. And the question was, how could it be, how must the world be structured? How must international law be reformed to ensure that this type of thing, which has happened for the second time within a short period from 1914 to 1941, how to make sure, and in both cases, the United States was drawn into the conflict against its will, really didn't really care, didn't want to get involved and got involved only late out of necessity. But it connected the intervention with the idea of a transformation of international law. The interesting aspect of today's situation is that there's none, really none of this reformist orientation we can observe with regard to the Russian invasion. It's all about rallying the troops and providing support for the Ukraine, which is perfectly good as far as it goes. But there is no focus on how the series of crises, and it's not just the war in Ukraine. Imagine that magically in a year or two, there'd be some kind of a settlement there. There is the Taiwan issue, which is also very difficult to imagine how this could play out without a major crisis and a real danger of a massive war. Or we have the problem of Iran and nuclear armament, where basically the United States under President Biden has already declared in the United Nations General Assembly that they regard Iran getting nuclear weapons as a red line, which would involve them using force to prevent it, or maybe Israel in their place, but it will not stand. So there are all these crises and these potentials for major conflagrations and major conflict. And you have to ask yourself, or one of the core issues to ask is, how did we get there? How is that possible? And how can we make sure that these types of things actually are less likely to occur? How can international law be structured in a way that it more adequately ensures that the types of situations that now seem to be arising in a steady pattern don't arise in a way that that makes it plausible and carries a real systemic risk of a major great power war, potentially involving nuclear weapons. So what I want us to do, that's kind of the introduction. That's the problem. That's what I see as the issue. And to get closer to what I think is wrong with the international legal order as it stands, I want us for a moment at least entertain the claims, the one-sided claims, and in the end, definitely I'm not claiming that they're justified claims, but to listen to what is said and repeat it not just in diplomatic contexts and on high-level politics where it's predictable what people will say, but what is being said resonates very widely in large parts of the world. So we ought to listen to it at least, and then try to ask, well, how come this kind of rhetoric has resonance the way that it does? And the kind of rhetoric that has resonance that you hear put forward also, but not only by Russian and Chinese channels, is the claim that the West, and that's how they will speak, is hypocritical. That whereas they make a big fuss now that Russia is invading Ukraine, they perfectly played along and at least didn't make a big fuss when it came to the United States and the way it engaged in the Middle East generally, not just the Iraq war, but starting already with Afghanistan and certainly moving on beyond Iraq to Libya, to Syria, the whole anti-terror list of policies after September 11, which involved the most awful and straightforward serious violations of human rights, from torture to secret detention camps to the whole panoply. I mean, so this is the claim. Now, I know we can go into each of these in details and look whether maybe here or there's not a legal justification, etc. Certainly, I teach part-time in the United States at NYU, and in U.S. conferences, a lot of attention and a lot of energy was always focused on looking at possible justifications for each of these respective steps. So the law at least played a role in thinking through these issues, even if in the end, most would conclude that a great majority of these types of actions were not covered by international law and were simply illegal use of force. That at least is a widespread perception. I don't think that perception is false, but it is a widespread perception. That's all. I don't care to relitigate the substance of the issues. This is the perception, and it's very widespread. So it's a widespread perception of hypocrisy in that regard. And when the response is, when you hear these stories and you ask, what's the response on the Western side? The answer is always, this is whataboutism. You point, there is something really terrible going on. Russia is invading the Ukraine. Daily, hundreds of people are dying. And you're talking about something that happened, 10 years ago. And this is just irrelevant whataboutism. And at any rate, there is no equivalence, because whatever you might say about those actions, Vladimir Zelensky is not Saddam Hussein or Assad or the Taliban or Gaddafi. Instead, we're talking about a leader of a troubled, an imperfect liberal democracy, but nonetheless a liberal democracy. So there is no equivalence. So that's the claim. But of course, if our starting point is international law and the prohibition of the use of force, and if what we care about ultimately is the well-being of persons, and we look at the victims of the policies of that decade, in terms of numbers, we are talking about the same order of magnitude. It is difficult to claim there is no equivalence between the two. So the right way, I think, of analyzing this is we have to embrace the fact that there is equivalence here, and that presents a real problem. And whether you agree or not, in the end, that doesn't matter. A wide part of the international community outside of the West agrees with this assessment. And that's a problem. And here's why it's a problem. If you look more closely at who actually is supporting sanctions against Russia, and who is actually willing to deliver weapons to the Ukraine or otherwise financially support Ukraine directly, it is a sad fact that the only countries are doing that are countries under the nuclear umbrella of the United States. With one qualification, so Australia, New Zealand, etc., are on board as well, but they have their particularly intelligence connection and close cultural and other affiliations with the West. But so generally, we're talking about the West in the narrowest sense, as those who live under alliances led by the United States. So in Asia, the only countries who are supporting these types of measures are South Korea and Japan, and so on. So this is a core problem, that outside of this core, other countries, Brazil, Indonesia, etc., they actually agree that what is going on is illegal. It's not that they think that this is a perfectly fine thing for a powerful actor to do. They completely agree with the UN Charter's view on this. This should not happen. It's a violation of international law. But they are saying, why should we invest heavily and share in the rage of what is happening now, when nobody cared about it when the actors involved were other actors? So, with other words, the perception of hypocrisy, which may actually be real hypocrisy, but I don't want to litigate that, the perception of hypocrisy undermines the effective coalition building and alliance building to rally around these types of blatant violations under international law, because outside of the West, of the core number of states who are more directly affected by this, the sense is shrugging of the shoulders and say, well, this is how the world appears to be. Great powers can get away with murder and unaccountable in the end. And we don't like it. We'd like it to be different, but we're not going to get highly roiled up about this if in this occasion, when there's no such response in other types of situations. So that I think describes politically a kind of the situation with regard to the sanctions regimes, the support of the Ukraine with regard to weapons delivery, etc. So what this suggests is that the status quo is not a satisfying one, because if we ask why is it true, let's actually one further step. Most persons, and here I think we've heard it as well, that there's something plausible and legally, I think, certainly correct for the International Criminal Court to have an arrest warrant out against the Russian leadership for war crimes. I find that perfectly plausible, but when we see the Russian response to it, it's actually entirely the same as the American response when the ICC started investigations. There was not even an arrest warrant. They merely started investigations with regard to war crimes committed by Allied troops, American troops in Afghanistan. It's pretty clear there were war crimes committed. We have plenty of evidence for that. But the point is that was being investigated on the same kind of legal basis as the investigations taking place currently because of acts undertaken on the territory of the Ukraine. And the response was to sanction the ICC and to point to the fact, to a previous law which was enacted post September 11, also to prevent the ICC from doing anything, which was an act which authorized, automatically, it was a congressional act which authorized the United States president, without further authorization, to use force to free any American personnel held in The Hague as a potential war criminal. So it was the authorization of the use of force to free Americans indicted for war crimes. So that was the American response to the ICC acting on universal principles, trying to ensure accountability for war crimes. So we have the same thing now with Russia. And you understand that there's a deep frustration among those who are not part of the Western bubble, where these types of stories are being told all the time. They dominate. Those are the dominant narratives in a wide range of countries. And it's in that context that we need to ask, well, how can we change that? So if we want to change, if we really want to build a global coalition and to take seriously the principles that undergird the existing international legal order and make it more effective, then we have to ask what exactly needs to change with regard to it. And here are a couple of things that currently, in my view, structurally enable great powers to get away with murder. There are certain distinctive legal features in the international legal order which make it possible for great powers to get away with murder, except, of course, when they enter into a competition with one another. And then we have the kind of great power competition and the potential of conflict where law really doesn't play much of a role. But the interesting question is, so we have, much of the great power competition we have these are powers that basically act not in a legal vacuum. They're legal primary norms governing their behavior, but it's generally understood that none of these actors, unless one of them wins, will be held accountable in any legally plausible way. So the question is, what is it? What are the structures which ensure great power and accountability, creating these types of situations? And I think it's the interaction of three kind of structural features of international legal orders. The first is the veto right of permanent UN Security Council members. If we ask who are the major great powers who are likely to get away with murder, get away with war crimes, then they're not only those five, but others will get away only if they have the protection of one of those five. So ultimately, the possibility to cast a veto and to ensure that a condemnation or a collective mobilization and the authorization of sanctions of various kinds can't take place is a very, very important part of ensuring unaccountability. Now, there are different ways of thinking about how this might be remedied, because of course it is utopian to think that through the formal amendment procedure of the UN Charter, somehow the veto would get abolished. That's not going to happen. But there are other ways that, as a lawyer, we could get into more discussions about, relating to the potential role of the General Assembly, as we already had here, under the Uniting for Peace process. But there are other types of legal techniques, also the idea that certain vetoes cast are invalid and thereby should not undermine or the UN Security Council authorizing actions. And so there are a number of steps one might think of, but I'm not going to discuss the steps here, the remedies. I want to just the direction in which remedies would have to go. I want to just focus on the problem. And the problem, first problem, is the existence of the veto. And there are ways to address it through legal interpretation and legal creativity, which does not involve something utopian. The second feature that enables this unsatisfactory state of affairs is the fact that it's still the case that general judicial accountability, that means a state that's being violated, that claims that its rights have been violated internationally, can go to court, to an impartial and independent tribunal, to have it assess whether what is occurring is illegal or not. I think that matters a great deal. And it is still the case that such courts in international law only have jurisdiction if there is consent. So a state has to have consent to it. And if we look more closely at the consent practice of the P5, we notice that there was a time in history when both the United States, Britain, and France had accepted the general jurisdiction of the International Court of Justice. But the United States, after it got condemned for its aggressive war in Nicaragua in the 1980s, pulled out. And when the French were called out by the International Court of Justice for engaging in nuclear weapons tests in a way that arguably violated human rights, they too pulled out. That's how great powers respond. They don't like that. They don't want to be called out by a court, so they just withdraw. And under international law, as it's predominantly understood, they have a right to do so. And that leads to a situation that in the United States, say post-September 11, there are lawyers making all kinds of claims. I think none of those claims would have had the slightest chance to be accepted by an impartial and independent tribunal, but there was no impartial and independent tribunal in which those who felt their rights to be violated could actually vindicate their claims. And so it was left open. Similarly, of course, with regard to the International Criminal Court. Now there, the situation is a little bit more complicated because, as we've seen in the case of Russia now, and we've seen in the case of Afghanistan when it came to the United States, it is possible to actually bring a case against persons who belong to countries that have not signed and ratified the ICC if their actions take place on a country that has accepted the jurisdiction of the ICC or otherwise supports its actions. So that's why we have, even though Russia did not sign and ratify the ICC, that's why it's possible to bring the case that the ICC brings. But notice, there are these cases about, it involves children, it involves, these are things that are important and they're terrible violations of human rights and of what they are war crimes. But the real issue, of course, all of these crimes are direct consequences of the original crime, which was to start a war in the first place, to aggressively invade another country. That's what in the Nuremberg trial was called the primary crime. Starting the war. Once you have hundreds of thousands of young persons fighting other young persons for their lives on another territory, they're going to be war crimes committed. That's what you might expect. That's what, by the way, we have that, of course, also happening on the Ukrainian side. But still, these kinds of things happen once there is a war. And so the real focus, the real crime, the most fundamental crime, is the act of aggression in the first place. And that is an act which you cannot, under current rules, prosecute against a leader of a country that has not signed and ratified the ICC. So in this case, it means there's no chance to get Putin for that, which of course is the core crime that you would want to get him for. So That's the jurisdictional problem we have, both with regard to general courts and with regard to the ICC. And of course, that problem would go away the moment we would have some kind of a rule, which was actually discussed in the context of negotiating the UN Charter, which was that if you join the UN by becoming a member of the UN, you accept the jurisdiction of these kinds of universal institutions. That's one package. Just as you accept the authority of the UN Security Council, you don't know what the UN Security Council is going to do in the future, and yet you accept its authority as a member state, any member state. So you should accept the authority of a general court and the authority of the ICC. Now, again, that's suggesting that may be very plausible and may resonate widely. It's utopian if we try to bring about such a result through a renegotiation of the UN Charter. That won't happen because the P5 won't want that. But there are other ways, again, legal techniques, which go quite some way. They don't quite get you where you want to go in the end, but they get you quite some way towards greater judicial accountability by reinterpreting the consent requirement, for example, and interpreting expansively the jurisdictional grants that exist. Again, I don't want to go into the details here. That's too technical, but I'm just, again, here pointing to the fact that for a committed international community wanting to hold great powers accountable, there are paths of moving forward, which would go quite some way, involving enhancing the capacities of the international system to hold judicially accountable great powers. So that's the second core point. UN Security Council, jurisdiction of courts. Finally, there is the issue of nuclear weapons. The current conflicts would be unthinkable in a context where there are no nuclear weapons. So it is often said that nuclear weapons haven't been used since the end of World War II, since July 1945, but of course that's wrong. Nuclear weapons are perpetually used as a threat in the background, as of course has been the case in the present with regard to Russia. There would be no question that NATO would not have come in and probably dealt with the issues with conventional means relatively quickly. And Russia would be defeated. Actually, Russia wouldn't have even bothered to try what they were doing if they didn't know that in the end they would always have nuclear weapons as a threat, which would preclude NATO from wanting to become a party directly to this conflict, because you don't want to get into a shooting war with nuclear power. So nuclear weapons are a deep and fundamental structural principle, which does not actually achieve stability. On the contrary, and it provides avenues for destabilizing otherwise existing balance of power arrangements, because as we see here, it merely becomes a question of subjective will and plausibility for an actor to threaten the use of force of nuclear weapons, and then the other side has to call the shots. Either believe that this is not serious and can't be and is just a threat, or alternatively believe that there is a genuine suicidal willingness on the other side to actually use nuclear weapons if pushed. And the idea that such suicidal possibilities is not with the realm of the possible is frankly, both psychologically and as a matter of history, ridiculous. So there's no question that if Hitler had nuclear weapons available in 1945, he would have used them. And some of the rhetoric that you hear coming from the Russian administration currently, such things as there is no world which is worth saving that doesn't have a powerful Russia within it, that type of thing, sounds very familiar. That's like Hitler saying, if Germany can't be a global hegemon, then the German people doesn't deserve to live. And so you might as well have them completely destroyed. Now, that's not quite the same thing, because Hitler didn't have the capacity to destroy the world along with it. But of course, if he had, then he would have chosen that path. So these kinds of...
Professor, could you please conclude?
Wrap up, yes.
Thank you.
So these three things, the UN Security Council veto, the jurisdictional problems relating to both a general court, which has the ICJ and the ICC, and thirdly, the problem of unaccountability, which is created through threats of use of nuclear weapons. Those three are the core structural features which enable the kind of great power competition we have in the present. And unless we think hard and move towards addressing these problems, we will stumble from one crisis to another, with a real danger of a major global conflagration as a result.